Good afternoon. We have with us Mr. Amir Singh Pasrich. Mr. Pasrich is currently Treasurer of the International Bar Association, IBA, one of the largest associations of lawyers in the world. He is also Secretary of the Legal Practice Division of the IBA. With a career spanning over 3 decades, Mr. Pasrich has practiced law in India, handling cross-border work for airlines, various governments, the diplomatic mission, the delegation of the European Union, and several Indian and multinational companies. He has been honorary legal advisor to the British Commissioner, agent of Her Majesty the Queen and Right of Canada, and continues to advise the Canadian High Commission. He is also counsel to the American Embassy in Delhi and the US Department of Homeland Security. Mr. Pasrich has advised the French government and the French Embassy, the Singapore High Commission, and many more. He has represented over a dozen international airlines and several landmark precedents from cases argued by him in court. He has handled situations for airlines beginning with Delta Airlines Inc. from 1995, British Airways plc from 2003 to 2007, and then 2018 onward, Swiss International from 2010, Air France and KLM from 1997 to 2013, Turkish Airlines, and many more, defending matters from the Consumer Fora to the Supreme Court. He has authored the Air Transport India Guide for Lexology for many years, as also for Lexology publications on product liability in India. Mr. Pasrich has a law degree from University of Oxford with specialization in international trade and commercial law. He was recently president of the Oxford and Cambridge Society of India. He also has a BSc degree from St. Stephen's College, Delhi University, and was schooled at the Doon School, Dehradun, with a term at Lakefield College, Canada. Mr. Pasrich specializes in arbitration and dispute resolution, having argued several cross-border institutional and ad hoc arbitration, having appeared in courts ranging from the Supreme Court of India to various high courts and district courts across the country. He has handled white-collar crime cases, criminal law work, and also complex cases relating to industrial and labor law, often assisting parties to arrive at a mediated settlement. He has handled and argued competition law cases and authored articles on antitrust law. Mr. Pasrich has experience in handling public procurement disputes and advisory work with involving government tenders and railway and other transport sectors. Mr. Pasrich is based in New Delhi and is married with 2 daughters. He has a passion for sport. He plays squash and tennis while continuing a horseback career as a #1 polo player. He enjoys trekking, reading, and traveling. On the other hand, we have Akshata Mathur. Akshata is a law student from Symbiosis Law School, Hyderabad, with a keen academic interest in dispute resolution, international legal institutions, and comparative legal systems. She regularly engages in legal research and writing, with a focus on contemporary issues affecting the administration of justice and the evolving role of international legal bodies.
Good evening, sir. My name is Akshata Mathur. It is truly an honor to be speaking with you today, and I look forward to this conversation on your journey, your work with the IBA, and the insights that you will bring from your decades of global legal practice. So with this, I'll start my first question of the interview. So to begin with, for our readers who may know you through your work with the International Bar Association and your international practice, but not the formative years, what first drew you to law, and at what point did you exactly realize that dispute resolution and international legal engagement would become central to your professional life?
Okay, so I didn't expect to be doing anything international when I started practice. It was quite normal, but I joined a law firm called JB Dada Chanji and Company, which was one of the biggest in India that was handling international work. And they were doing the Union Carbide case at the time. I don't know if you heard of the Bhopal gas disaster. So they were handling it with Mr. Fali Nariman as the lead counsel. And I was an intern. Then I joined the firm a year later. And I did some of the work involving that case, but more interestingly, I did a lot of work involving, foreign clients like Hitachi, Coca-Cola, and multifarious Japanese and American and European clients that the firm was dealing with, because they were one of the foremost at the time. And I sort of fell into this practice purely by chance, because in 1997, which is quite recent, of course, I went to New York for my first introduction to the International Bar Association. And they were celebrating their 50th anniversary. And I went for that meeting, and they said, "We're coming to Delhi in 3 months." So I said, "Oh, how nice." "What are you doing in Delhi?" So they said they were doing their first international conference, which is their big conference in Delhi. And they didn't have very good contacts in Delhi. The main person was one very well-known lawyer called Mr. Lalit Bhasin, who was handling everything. And so he was a focal point of the conference. But we were able to do a lot in that conference. And I gave 3 speeches, which was quite a lot. I've never given 3 speeches after that in one conference over a 5-day period. They also came to inspect my offices for what were called law firm visits. They came home to my house, and we met a man called Gerald Herman, who was the father of the arbitration law. And his favorite joke was, "If I'm the father, I don't know who the mother is." But Gerald Herman, with his wife Ingrid, came to my house at that time, just after the 1996 Arbitration Act. And he had made the model law of the UNCITRAL on which this was founded. So exposure to all these different elements suddenly put me in the forefront of international law. There was also one Mr. RKP Shankardas, who had been president of the IBA, who was very close to us. So he introduced me to cross-border practice.
Okay, thank you so much, sir. So this gives me to the next question, which is, I think you are one of the most senior-most office bearers of the IBA, International Bar Association, from India, having joined IBA in 1997, I believe. Could you take us through your journey with International Bar Association from your early years to your present role today, and what the future actually holds for you?
Yes. So the IBA itself is something which is huge. It is 83,000 odd lawyers, and it also has about 160 or 170 bar associations that are members. So effectively, it is the global voice of the legal profession, because it connects the whole legal profession around the world together. And I never thought that I would make it to being at the helm of this organization, but I'm on the management board today. And I see some of the most interesting things happen. We look at controversies as recently as the issue of Venezuela has been a matter of discussion, the situation in the Middle East, the Ukraine invasion and its consequences in international law, the possibility of criminal consequences for certain people. All this becomes discussed. It is discussed, sometimes even at the board level, which is very interesting. And then the other thing, the fun part, is that we frame a lot of interesting new rules and regulations. The IBA rules on the taking of evidence in international arbitration is one of the most amazing documents that has been used around the world. So as they improve on these different policies, rules, procedures, oddly enough, many of them come across our desks. That is the what is called the LPD officers, Legal Practice Division. I'm number 3 in the LPD as treasurer. There's the chair, there's a vice chair, and then treasurer, me, and then there's an assistant treasurer. There's 4 of us. And we look at these things and we decide on whether they're good. We give our ideas, we give our inputs, and then they become part of the IBA's library of precedents, documents, policies, etc. So there's a lot of fun there. You asked if what's my journey been. I'll be quicker on that one, but it's been a lot of challenges. I think you have another question coming later, which you had mentioned to me, that how difficult was it? It's been a tough journey. It started with assistant subcommittee chair, in 2000. That was 26, 27 years ago. And then it progressed into different offices of the IBA. Finally, I think the toughest one was an election. I'll talk about that a little down the line in this interview. Thank you.
Thank you so much for sharing your experience, sir. My next question would be your legal experience and your IBA responsibilities, as we all know, have grown in parallel to each other. So, to what extent have these two roles complemented each other, according to you, and what are the challenges that IBA work posed for you in your professional practice?
Well, time is the big one. I did something quite naughty last week. Somebody called me up and started trying to do some marketing. And I said, आप चोरी कर रहे हो. हम क्या चोरी कर रहे हैं? I said, हमारा समय. You're stealing my time. And, it's become such a habit of people to call you up and take your time. And the phrase time is money is not a fair phrase because it's not directly translatable to money, but it's really your most precious commodity. So sharing it, whether it's with the IBA or sharing it in your practice or with your clients, your family, you have to put those, the famous example of golf balls in a jar. You have to put the golf balls and you put the sand and fill up whatever's left. That jar is your time. And the golf balls are the big things that matter, your family, your your professional pursuits, your clients, and a little bit of time for yourself, your pursuits. Yesterday, I had the privilege of getting onto the polo field after many months, and I played on horseback. So balancing that life between these two, balancing the IBA's, the necessary time commitments that you have to keep giving, whether it's for an audit committee or whether it's to look at some important new policy, or it's to attend even a management board meeting online, or to travel. I think I travel about 3 or 4 days a month, and always outside India. So it's a lot of time commitment, and you have to tell your courts, your hearings, this is what I'm doing. So priority is a difficult challenge, and I think I manage it well by looking at least 3 to 6 months ahead. That's how it works in my life.
That offers an important perspective. So my fourth question to you would be, through your long association with the International Bar Association, what are the lessons that have most significantly altered your perspective on the legal profession and on life generally? And has this experience changed how you conduct yourself, maybe more professionally?
Everything changes how you conduct yourself professionally. I was arguing a case about 2 days ago, and the arbitrator and I was explaining to him that, there are 16 conditions we've put down for saying closing a contract. I think 12, about 12 or 16, but the 12 were important ones. And I said, if you have to shut down a contract, you have to close it down on one. So he looked at me and he said, what is your point? So I remembered something from the IBA. I said, Your Lordship, in 2015, I was talking to one of the officers of the IBA, and I said I was going for an election against 10 people. And they said, if you want to be on this council, you'll have to beat them all. So I laughed and I said, I think you've got the wrong end of the stick. I don't have to beat them all. I just have to beat one of them. And that's part of life, that's a life lesson, that you have to understand your priorities. Do you have to compete with, the whole world, or do you have to compete with one person who might be at the end of the race and you just want to pass him and stay in the race? Or do you have to come as number one? Those are life lessons. And I think part of that challenge that I went through in the IBA at different times has taught me how to conduct what I do even in practice. I mean, that what came from there is the story of the bears. You must have heard there were bears outside, and there were two people in a tent, and one of them was putting on his shoes, and he said, "I don't have to outrun the bear. I have to outrun you." So those are life lessons, and you have to consider those in both perspectives.
Taking that thought forward, you have served on the IBA Management Board and you're currently its treasurer. So, what lessons from this leadership journey are particularly relevant for young lawyers, in your opinion? And also, can you share one meaningful change you were personally able to help bring about under this?
Yes, that I certainly can. I had just joined the management board, and it was 8 years after the IBA stopped the discount for Indians, not just Indians, but all the developing world. We used to get a 40% discount. And I reminded them that they had got rid of this discount in the Vienna conference in 2015. And I said, it costs so much for Indians, and particularly young lawyers, to come to an IBA annual conference. It's like 3,000 euros plus tax, etc. So many of them fall by the wayside because they put their pennies together. I remember when I was a young lawyer and I went to my first conference outside India in Barcelona. I stayed with a friend, and my wife and I stayed in his bedroom and he stayed in his drawing room because he was also my batch and young person. And, we just managed to attend that conference. We flew economy class. We stayed with a friend. We paid the conference fees with difficulty. So when a young lawyer has to go for the IBA, it's very tough. And after this board meeting, which happened in February 2023, my first, it was recorded that we have to relook at this. And then I became treasurer in 2025. And the treasurer has to protect the monies of the association. So it's a bit of a conflict. But when they pushed this through and they brought it back to the forefront, I was very strong in defending it and saying that the developing world, all the young lawyers, need to have something that will get them incentivized. And a minimum 40% discount would be great. It's just money. And we should try and work it out so that we have more numbers from the developing world to balance out this 40% discount. And I'm pleased to tell you that with effect from this year, 2026, for the first time, Indians, lots of developing country people will get a 40% discount. And that was passed in November 2025.
Okay, that was very informative. Thank you, sir. I will ask my next question to you, the sixth question. That is, the International Bar Association often acts as a bridge between legal systems, as we know. So can you share an instance where comparative exposure through the IBA influenced your approach to a dispute or a legal strategy in our country?
Well, one example I think I'd given you about how I used that, that election for my purpose. But actually, bridging legal systems is something we discussed in December 2025, last month. Justice Manmohan was asked by me, I was the moderator at the opening session, as to who, or what case or what thing had influenced him most in his legal journey. And interestingly, he said Keshwananda Bharati. So, of course, we all know Keshwananda Bharati, and we just been to the, Jindal Global University. They had a recreation of the Keshwananda Bharati case at the moot court that they were setting up, and they had brought 13 Supreme Court judges to do this, sitting Supreme Court judges, which was quite an achievement of Raj, the Vice Chancellor. And when they did that, Keshwananda Bharati was, a matter for the government to oppose. If you think about it, governments don't want a basic structure doctrine. It means that you can't go around changing the constitution at will through parliament. and even if you get a super constitutional majority, which can change the constitution, you still are hampered by the Supreme Court that can look at that change and say, oh, 368(4) says that the change should not take effect. That's Keshwananda Bharti. And we all now, as lawyers, believe in this doctrine. Okay, we've grown up with it. That's what the Attorney General also agreed with me recently. So he was speaking against Keshwanand, and Abhishek Manu Singhvi was arguing in favor of the whole thing. But that was all part of a moot court. In our hearts, if you ask the Attorney General or you ask a judge of the Supreme Court, Manmohan is a judge of the Supreme, Justice Manmohan is a judge of the Supreme Court, the answer lies in Keshwananda Bharti is part of our DNA. So why does it matter? I'm telling you this because in this session, what we were talking about is other countries need Keshwananda Bharti. The United States might be one of them, you know. The UK is one of them. It has a relatively new Bill of Rights. We are older than the United Kingdom in our Bill of Rights. Theirs was unwritten until very recently, till the last century, towards the end. I've forgotten the exact date when they enacted their Human Rights Act, but they didn't have a written constitution. They didn't have entrenched bills of rights. So maybe it's time for the world to pick up on a basic structure doctrine and to say there's certain things you can't touch no matter what. And this is one of them. So Keshwanand should be, and then there are other things you can transplant from India. And the question arises, what can we transplant from the West? And I don't know if you've seen some of those legal serials on TV, etc. The judicial system of the United States decides things very fast. You know, they know how to take decisions without looking back and looking over their shoulders. They're not presumed to be corrupt just because they've taken a decision one way or the other. And we are suffering delay to a point of craziness. Our governments don't decide, our authorities don't decide, and then you go to the courts and they hear a matter twice or thrice over for 2 hours at a time, and then the judge changes and the roster changes and the matter is left unheard. So that is something we have to learn not to do.
So I'll ask the seventh question. That is, sir, if you were advising young lawyers today, would you recommend them pursuing a career in the international law? And if so, what are the concrete steps, according to you, they should take to build such a practice from a country like India?
So this idea of being an international lawyer is quite difficult to explain. International law itself is something which it exists in a rather hazy world. You can be an international lawyer at the UN. You can be an international lawyer dealing with cases at The Hague. You can be an international lawyer dealing with government-to-government relations. That means you have to be in the government. You can be an international lawyer who works with the government and advocates their cause, or with defendants who are suffering government oppression. So these are certain specified fields. To be a commercial international lawyer basically means that you do things like international arbitration. You advise, certain types of parties. I've been a little lucky. I've advised the United Kingdom. My first client was the government of Singapore, and advised the Singapore High Commission. I remember appearing in the Delhi High Court for them in the beginning of my career. Justice Amit Bansal's father, Arun Kumar, said to me, the Singapore High Commission, there's no such client, you can't have that. I said, Your Lordship is absolutely right. He said, the Singapore High Commission, as far as I know, is a building. I said, that is absolutely correct. And as you might know, there's only the government of Singapore, and there's no such thing as the Singapore High Commission that is a building. So these kinds of distinctions and understanding of law is a matter of experience. You go through life and you see what happens, and you dabble in things that have cross-border implications, and you become that kind of lawyer. I know someone who's worked in handling international criminal disputes, and he has he's a well-known senior advocate now. He's doing very well, but he's worked in international tribunals as if I remember correctly, it was Milosevic. So he has that knowledge. He even taught in an international school. So it's how you shape your career. You have to decide two parts. One is the knowledge, and the second part is the practice that brings you money. Both are important. So that's my answer about steps to be taken. You have to frame those steps, working into the directions that you tell yourself, this is what I want to do, how I want to do it. And for God's sake, as you get older, do it rather than thinking about it. That's my advice.
Thank you, sir. My eighth question to you would be that, as you know, India continues to struggle with dependency across courts, as you have mentioned earlier in this interview as well. So in your review, what are the most critical structural bottlenecks, judicial, procedural, or even cultural, that often tend to delay the dispute resolution in our country?
So first part of this answer is, what are the problems? I think you need to ask those. And the word cultural, strangely, is very important. India and our judges don't like to shut you down. They're not very, they can be, I mean, the really tough ones, tough judges are pretty tough. But on average, judges have a tendency to just listen to the parties, and then say, okay, even though I'm going to give you a decision against me, you take it from the reader, take it from the court, judgment reserved, and you get it later and you're surprised you've lost. Because they don't necessarily culturally to your face say no. And why I'm saying that matters is because it affects the administration of justice now. Judges need to say no to you to your face, especially for procedure. If it is time barred, it is time barred, it is over. There's no question. Why should you have a limitation act if you can keep condoning delays? And if there's a genuine case for delay and it has no impact on the other side, do it fast. If I give you an example, you'll be shocked. I had a case involving an international airline, and the written statement was delayed for no cause of ours. It was just, there was a mistake in the order. The court eventually set it aside. And I told the other side, I said, don't oppose me, please. You will lose time. I know I'll win on this. And it took 3 years. 3 years before that order was set aside and we went ahead with the dispute. So what's the point of being like that? And there are many examples there that are cultural. So you need to talk to the judges and to explain some things to them across the board. You need to retrain some of the judges. You need to inject some of the things that we've learned from abroad into the decision-making process so that it's done and fast. I can give you one more example. In the Delhi High Court, I argued a matter for 3 days before in one case. And then there was no judgment. The roster changed. It came up before another judge who looked at me and said, what were you doing for 3 days? And I said, arguing. There's nothing in this matter. I said, I agree. 15 minutes later, we had a judgment. 15 minutes. So it depends on the person's competence and interest in that subject also. And if you give it 3 hours, you're using precious judicial time. And then if you don't decide, you're committing what is the cause of the delay. The pendency is caused by that. It happens at every level. And fomenting litigation is something lawyers have become very good at doing if it protects their clients. That's the system. I would be guilty of it too. Why? Because if you tell me, look, you need to look after the best interests of your client, and an adjournment serves his purpose really well. He's got a stay, it's this, that, and look, taking a decision at this point is not going to help you. Why would I rush matters when the whole 5.3 crore cases pending in the country is on a similar footing? I need to have an across-the-board process that speeds it up. And to speed it up, we need to have some basic rules. The rules have to be no adjournments for these grounds. The rules have to be maybe a lawyer gets rated for taking adjournments. A judge gets rated for the amount of time that he spends hearing cases and deciding them. Okay. Judges should also have a system, especially, I mean, at the district court level. And you can't wipe out judicial holidays. They use them to write judgments. So there's nothing wrong with that system. The wrong is done to the system because you're overburdening people with 100 cases when no human being can decide 100 cases in a day. Yet you have courts with 100 case lists in there. So we need to have a system by which we funnel the cases down, give that judge, him or her, 20 cases and say, Zara, these cases का decision ले लो. 80 cases को registry को भेज दो. बोलो तारीख दे दो जो मर्जी करना करो. ये urgent नहीं है, ठीक है. But don't put it before a judicial officer, a judge, to decide on a date. He spends 40 to 50% of his time in a court deciding on dates. That's across the country, whether it's a district court or the high court. Go to a court, that's what you find. What are they doing? I got a list of, not uncommon in the Delhi High Court to have 60, 70 cases a day. Sometimes 50, sometimes 60, supplementary come out, 70. And you know that certain judges are not going to reach the end because they're very kind judges. They listen. They even sit till 6 o'clock. And then they say, Dekho, 6 baj gaye hain. I'm going home and I still got 10 cases left. So for that, you must have a pre-judge hearing, which is done by a registry officer who says, look, I'm not going to put this matter before the court unless you both are ready. There's nothing to be done by the judge except a hearing. And let's funnel it down, 17 to 20 cases a day before every court. And the others are adjourned by the registry, not by the judge. So that's one example, and there are many others. This is also part of a project that we're doing called Accelerating Justice, and I'm pushing that project through, which hopefully will, in the next few months, become quite significant. That's an IBA project.
So on a similar note, I think my ninth question would be, looking at a specific case or any project or any initiative, can you reflect on how the International Bar Association has made any tangible contribution to strengthening the rule of law or advancing a particular area of any legal practice?
So many now, it's wonderful to find them all so easily available on the website of the IBA. In arbitration, for example, I was quite gobsmacked, is a nice English word, where I discovered that they are looking at res judicata in arbitration awards. So that was recent. AI in arbitration, which is scary actually. The American Arbitration Association idea of having AI arbitrators is slowly gathering steam, and the IBA is doing something on AI to bring it to the fore and to also look at restrictions and rules and regulations on AI. And the other fields have been, I think, when I was chair of the International Commerce and Distribution Committee, we had something called a checklist on how to do a transaction involving cross-border international sales agreements. So if you were buying, say, a big plant in Germany, or Germany was buying a big plant in India, which is something I've done, the checklist of what all you should put into your agreement was put out by the IBA. They had one on their website. So you get every committee. We had, I think, 49 or 50 committees of the Legal Practice Division producing papers, documents, special projects, and they're all out there. There's an incredible source of wealth of information that the IBA gives and keeps putting out, not to mention the webinars, which are publicly available. And then if you remember, the conferences.
So my next question to you would be, what has been your most challenging moment with the International Bar Association, and how does that compare with the biggest challenge that you have faced in your professional legal career till today?
Well, I think biggest challenges in professional legal careers come from court and hearings where you just don't want to lose because you know that you're on the right side of justice, but you don't know whether the judge will be with you. So when you walk into court, you have this sometimes this fear that the other side has been putting forward a wrong story, and you have to counter that, and you have some nervousness, and I think that influenced me also in some of the challenges I faced in the IBA. One of them I recounted earlier today, and the other one I think was in 2022 when I stood for assistant treasurer, and I went for an election, which was a difficult one. You had, all these countries out there, you had to get their support in a physical election that happened in a foreign country in the United States, in Miami. And you didn't know how big the electorate was. You didn't know who was going to come into the room. You didn't know who was attending the conference and how many people would actually go for that. So I think that election was one of my biggest challenges. I won it. That was lucky. As you look back that you won it, because I think I had a worthy opponent. He was a very good person. And in retrospect, you see challenges like that from time to time. Sometimes you see them because you want to achieve something. Getting the Accelerating Justice project done and to achieve something. Accelerating Justice project is not just for India. It has now become a global project. So we want to look at reforms in different countries and try and transplant them, learning from different countries, like the experience of Canada, Malaysia, Singapore, so many countries that have speeded up their legal systems. And we want to take that and give it to India and say, look, to India and many other countries and say, look, you can use these measures. And they don't always mean just more judges and more money. They mean quicker decision-making, smaller dockets, lots of things. AI, the advent of technology, systemized filings, digitization of records, quick access to the judges so that they don't waste time writing judgments. All that is cutting edge of the future for dispute resolution. And I think that has come to me from the IBA.
That leads me to my next question, that you have advised and represented a lot of foreign embassies, governments, and even multinational entities on sensitive international, labor, and even diplomatic matters, as we know. What unique challenges arise when law intersects with diplomacy and state interests, in your opinion?
It's a very interesting question because in representing some of these governments, and I have also been in, Indian government offices once or twice with meetings with the government officers. I have met I remember going back, we had a security issue with an airline, and I had to meet the Ministry of Civil Aviation because they were about to shut them down. And then they didn't listen to us. We went to court, and then we came back a week later with a court order. So there's a fine balance between threatening and doing the practice of law in the interest of your client. And I think one of the most important things one has to, for me, it's work. I don't know how it works for others, but one must not put your own profession or practice first. The most important thing you must do is to put the client's interest first. It makes such a huge difference. I've seen some of our lawyers on the planet, I won't say necessarily in India, who focus on getting their money through earning their, making sure that they've been paid in advance. They've got all their ducks lined up for, the client relationship. But the surgery was successful, but, the body is over. The person is dead. The patient is gone. You can't do that for your client. You have to, when you work with states, governments, and have a bigger, broader perspective, you must look at many angles that affect the client and not ever put something which will perpetuate the problem. and let it grow from a small little issue into a litigation, into something that harms the interests of that client. There's not enough idealism out there.
Okay, so that brings us to the final question of this interaction today. So, with over 3 decades of legal practice behind you, could you share any one or maybe two landmark professional achievements that you consider today true change makers in your career till date?
Yeah, I guess so. I think there are two, which I can think of offhand, which are really a little fun. One, both of you would be very pleased, Shubhra, Akshata. In 2004, I went up to a senior counsel and I said, I don't understand why this section is there in the Hindu Succession Act, making women inferior to men. Section 6 allowed Hindu HUF to allow only males and not women. And there was section 21, I think, which said that a man could, but a woman couldn't, ask for partition of the Hindu undivided family house. So the senior counsels I went to, 2 or 3 of them, mind you, still very famous people, and they're around today in the Supreme Court, said, Pasrich, there's something wrong with you. This has been on the statute books for 50 years. The Hindu Succession Act is 1956, and we are in 2004. And what are you talking about? So I said, if it's wrong, it's contrary to the Constitution, that little document over there, which clarifies that you can't have inequality, especially for women, and positive discrimination, but you can't have this. He said, well, this is the balance that was struck. So I did a little research and I discovered that Nehru, in fairness to him, had done a sort of balancing act between the rights of women and the rights of men. And the pendulum hadn't come right to the center yet. So, and I'm bringing up Nehru because he brought out the 1956 Act, and there were many protests on the street at the time because it was said to be an incursion into the rights of Hindus per se. It imported some elements of Westernism into India, where your succession was not decided necessarily by Mitakshara law, but was being decided by the schedule to the Hindu Succession Act. And women still didn't get the same balance because of these two sections. Anyway, there was a Law Commission report in 2000, which had just come out 4 or 5 years before. And the government was meant to bring out the bill. So we moved a writ petition. And, I was so surprised that the government came back in the first hearing. Ashok Desai appeared with us, leading us, and he took the case without charge. And he said, my lord, this is the situation, and we can't let it continue for women. And the Hindu Succession Amendment Act was passed 5th of September 2005. That was one. And you said a second one. I think I have an obsession with the law's delay in India. And I've been bringing it out for the last 10 years. So the Accelerating Justice project of the IBA is that. And we hope that we'll be able to bring together maybe, the three arms, the executive, the parliament, to do something. Once they recognize that this is a serious problem. Outside India, India's perception on the world stage for commerce and, for economics is seen as one that is hamstrung by a legal system that is too slow and has too much pendency. So either we address it there, and if we can address it in India, we can even address it in other countries so many former colonial countries still have the British hangover of, cross-examination and trial, full-blown trials where things can be decided shorter. And we are taking those steps to shorten the trial process. So Calcutta has the worst history of having, I think, the largest number of cases that are more than 50 years old in Calcutta. So obviously that's an attitudinal problem. Also, they need to look into it, because why should it all be in that? That's a statistic. So hopefully they will look at it and start seeing what is the systemic problem leading to this growth of cases, and we should bring it down to not more than 5-10 years to decide a dispute at the most. To have an average which goes beyond 10 years is absurd. You cannot have a dispute festering for 2 and 3 generations, which is still happening. And that's something that I'm trying, and I hope to bring about some change.
We thank Mr. Pasrich for sharing his time and insights with SEC Times. His reflections on international legal engagement, institutional leadership, and dispute resolution reform offer a valuable perspective to the legal community, particularly young lawyers seeking to navigate an increasingly global profession. Thank you so much, sir.
Thank you.
Thank you, sir.
Have a great day.